Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. Glad to be with you.
Hey, Sam. I think you hear this question at least once a day, every day that you're at the office, and that is, if I end up in a lawsuit with my HOA and I win, will I get my attorney's fees back? Is that an accurate statement?
Religiously, multiple times a day.
We hear that so many times a week that it occurred to me we ought to do a podcast on it. Okay? It's a question that everybody asks, and it's a great question, and it's an important question because you spend a lot of money on attorneys in a lawsuit. Litigation's expensive, horribly expensive. And it's really annoying when you spend money and for a good cause, because you're right, and this is justice you're seeking, and you win and you don't get your attorney's fees. And the other side knows that, and they play games. It's why I think our system is partially broken, to be honest. But our system works on something that is called, famously, the American rule. And the American rule, very simple definition I'm going to give you, but basically, and it applies to every state, but we're talking about California because that's where we are, okay? And this is for every kind of case, every kind of civil case, okay? Not just HOA stuff. But the American rule basically says that there are only two situations where you are entitled to your attorney's fees if you prevail. One, there is a statute, a law, that says if you win, you get your attorney's fees. I'll give you some examples, okay? Most of the labor claims, if you're an employee suing an employer for failing to pay your wages or failing to give you overtime or any of those kind of labor claims, the statutes in California have built into them that the employee, if the employee prevails, they get their attorney's fees. Or even the Solar Act, the act that mandates people's right to install solar panels. If you have to sue under that, it's got a built-in attorney's fees clause. There are lots of statutes that have that. And so if you're suing under one of those statutes, then if you win, you get your attorney's fees. That's the first instance under the American rule. But there's another instance under the American rule where you're entitled to attorney's fees. Sam, what's the other one?
Yeah, so it's fantastic if you have a statute that's on point and provides a basis for it. The other way to do it is if you have an operative contract that has an attorney's fees provision.
Okay.
And so if there's a basis for recovery of attorney's fees or reasonable attorney's fees under that contractual provision that speaks to that issue, then that's the other basis for it.
So a lot of contracts, and if you want to look, you can pick any kind of contract you might have in your drawer, your lease if you're a renter, or your mortgage document, your mortgage agreement, or a promissory note, or a loan agreement, or an operating agreement if you're in an LLC. Just look at any contract toward the end and see if there's an attorney's fees provision. It'll say something along the lines of, in any dispute regarding the interpretation or enforcement of this contract, the prevailing party is entitled to their reasonable attorney's fees. It'll say something like that. Yeah. If it has that language, then that language applies and you are entitled as a winning party to your attorney's fees. Now, here's something interesting under California law. Even if it's one-sided, let's say the contract says if the landlord has to sue under this lease and wins, the landlord gets her attorney's fees. The law is read as being mutual. So it would apply to the tenant too. But that's a very, so that's it. Two situations. You have a statute, you have a law that says, oh, by the way, if somebody has to sue under this law, they get their attorney's fees, or you have a contract that does it. If your situation or conflict or dispute doesn't fit into one of those two, then you could spend all this money litigating and all you get is whatever your damages are. And every dollar you spend is a dollar out of your pocket. That's just the way our system is, okay? Exactly. Now, let's then transition into what we're here to talk about, which is this podcast is dedicated to HOA disputes. Yeah. And so let's talk about HOA disputes. Now, I'm going to say kind of a broad rule, and then we'll get specific. In most HOA cases, especially the ones that come through our office, there is an award of attorney's fees to the prevailing party, okay? And I'll explain why that's the case in this section we're going to talk about now, okay? Let me broadly say, though, the reason for that, very broadly speaking, and then we'll get specific, is twofold. Remember, the American rule says if there's a statute or a contract. Now, it can be both. And in many HOA cases, it is both, okay? Most sets of CC&Rs have a provision that awards attorney's fees to a prevailing party. And under California law, CC&Rs are considered a contract, for at least for purposes of attorney's fees. Under the Davis-Sterling Act, the CC&Rs are treated as a contract. They're interpreted with the same legal principles as a contract. So if the CC&Rs have an attorney's fees clause, that's going to be deemed a contractual provision under the American rule. And Sam, we also happen to have, we talked about some, there's lots of laws out there, lots of statutes that have attorney's fees clauses.
Right.
The Davis-Sterling Act has one particular one, doesn't it?
It does.
Talk to me about that one.
Well, under the Davis-Sterling Act, you have
I'll be specific. 5975, the Civil Code, right?
Right.
Okay.
Correct. Yeah. So it incorporates by way of the Civil Code as part of the Davis-Sterling Act that applies to HOAs, common interest developments, and it basically provides for a reasonable attorney's fees recovery for a prevailing party in a lawsuit in litigation.
Okay. What kind of litigation?
Well, a litigation for enforcement of the governing documents specifically.
Right.
Yeah.
So we are going to unpack. So basically, and again, I don't have the statute in front of me, so I'm not going to quote it out of memory because I can't, but I'm gonna paraphrase it. The statute basically says that in any enforcement action, and again, we'll get into the specifics shortly, but in any enforcement action, the prevailing party is entitled to their attorney's fees. Okay? But that's a lot to unpack, that very simple statement, because we have two terms, two phrases in there that need to be defined. One of them is what's an enforcement action, and we're going to talk about that in a moment. And then the other one is, what is a prevailing party? It's not as simple as people think. You either win or lose in a lawsuit. It's not always that simple. Sometimes it's hard to determine who a prevailing party is. There's a whole body of law that helps do that, and that's what we're going to discuss as well. So under 5975, a prevailing party in an enforcement action under the Davis-Sterling Act is entitled to attorney's fees. So let's talk about what enforcement action and prevailing party is. Let's start with prevailing party because I think that's the more important one, okay? It's not just technically who necessarily wins, because what is winning? Well, let's talk about that, okay? The way the courts have ruled, prevailing party, or the winning party, is the party that achieved their main litigation objectives. Well, what does that mean? Now, to me, when I think about it, because I've read so many cases over the years, to me it's very simple. I know exactly what that means. But to you, you might be like, well, that's just as difficult to understand as prevailing party. I understand you. I hear you. So we're going to describe that, okay? So do you have an example, Sam, of a situation that would yield a good result for our client because they achieved their litigation objective?
Sure. Let's say it was, an enforcement of the governing documents and pursuant to, let's say, a statutory basis.
Either one or both.
Let's say it's a solar energy system, and they proceed with litigation, and there's a decree or adjudication entirely in their favor, right? Or by way of summary judgment.
So a jury rules in their favor.
Right. Or a dispositive motion.
Let's just go with a simple one. A jury rules in their favor.
Unequivocal win. Right. And so you have a judgment in their favor. It's not a partial victory for the association. It's a complete cleanup, so to speak, in their favor. And now you go to where they are deemed the prevailing party or the winning party in that instance, right? And they would be entitled to recovery of attorney's fees.
Okay. So Sam gave us, it starts with, I like doing this, started with the easy case. You win.
Yeah.
Okay. Let's say, in his example, we sued, you, the homeowner, so we on your behalf sued the HOA because they refused to allow you to put in your solar panel. And by the way, you have multiple statutes awarding you attorney's fees there. You have the Davis-Sterling Act, 5975. You also have that Solar Act as well. So that's you have three bases because your CC&Rs probably have an attorney's fees clause. So there's three bases there. But under his, they refuse to let you in. You sue them, and it's enforcement because they're violating your rights under the governing documents, because a lot of governing documents kind of parrot or mirror the laws, and a lot of them have solar stuff in them, right? So it would fall under that. And so under his scenario, you sued, the jury agreed with you, said the HOA was wrong, you win. That means you're entitled to your attorney's fees. That's the easy case. Let's do a little harder case though. Let's say you sue to force the HOA to do something they're not doing. I'm going to make this up. Let's say I'm suing because the HOA is refusing, they've removed trees that were very important to our HOA, very valuable, provided shade to a group of homes. They removed them without permission, without any public discussion. without notice to the homeowners, and they haven't replanted them. They haven't put them back. So you sue to force them to put it back. And while the lawsuit's pending, the HOA goes ahead and plants the trees. They bite the bullet, they plant the trees. So you dismiss your lawsuit. You're the prevailing party. Your lawyer should be filing a motion for attorney's fees because you achieved your main litigation objective. Even though the lawsuit's gone and there was never a jury ruling or a court ruling, you sued them to make them plant those trees, and they did it. There's no need for the lawsuit anymore. So you dismiss it. You're the prevailing party in that scenario. Okay? That's not quite as obvious as the example Sam gave,
right.
But it still applies. Okay? Another example, you sue because of selective enforcement, right? Well, now, let's say, forget that one, because that one would go with yours. Let's say a jury agreed that you were treated unfairly.
Failure to maintain.
Yeah, failure to maintain. Okay? Let's see. I have even another one. Let's say you sue the HOA for unfair, they've applied interest and penalties in violation of AB 130.
Oh,
okay?
Yeah.
I'm just to pull in a new law.
Yeah.
Let's try that, okay? So you sue them for that. And then somebody on the board figures out, or the lawyer on the board figures out, oh, guys, yeah, you didn't follow AB 130. This was a mistake. You need to rescind those. And they notify you that they've rescinded that. So you dismiss. It's similar to the last example I gave. Yeah. You just achieved your litigation objective. You're the prevailing party.
Right.
Now, Sam raised something important because he said in his example, which was the easy example, jury comes out, finds for you, doesn't find in favor of the HOA in any way. It was just a one-sided victory. But he also raised this thing about a mixed bag. He kind of talked a few minutes ago about what happens if maybe a little bit of both sides win a little bit. Let's say the HOA cross-complains. They file a cross-complaint against you for something. You win on your lawsuit and they win on their cross-complaint.
Yeah.
Sometimes the court will go, it's a wash. There's no prevailing party. Even though you're both the prevailing party, the court might say, well, the values of the things are pretty equal. You know, whatever they're suing for monetarily, damage-wise, or objective-wise is equal to what you were suing. It's a mixed bag, so I'm going to call it a wash.
Right.
In that case, neither party would be declared a prevailing party. Or there could be a situation where you sue the HOA for something and they defend. You sue for, let's say, 10 causes of action and they defend and they win on 5 and they lose on 5. Now, they haven't brought their own lawsuit against you, but they've defended. The court might call that a wash, depending on if the ones they lost on were kind of equal in value or importance to the 5 you won on.
Yeah.
Okay, so that's how you define prevailing party. All right, we've given you some real-life examples that should help you understand that. Now, so with that in mind, let's talk about what's an enforcement action, okay? Enforcement action is basically a lawsuit where one party is suing to enforce the governing documents against the other party, okay? Now, the other party is going to either be the HOA and or another member because nobody else is going to be governed by your governing documents,
That's
but
right.
those two parties. It can be both and or, but it's going to be against your neighbor. For example, if you're going to file a lawsuit against a neighbor for causing a nuisance, okay? You're going to sue for nuisance, and you're going to sue, which is there's a statute on that in California, not part of the Davis-Sterling Act, but you're also going to sue for enforcement of the governing documents precisely because you want to get your attorney's fees upon prevailing. If you just sue for nuisance, that statute does not have an attorney's fees clause.
Yeah.
And there would be no contract involved. So when you just sue for nuisance, you don't get your attorney's fees. But if you sue for nuisance and enforcement of governing documents, or just enforcement of the governing documents, then lo and behold, you prevail, you get your attorney's fees because 99.9% of the CC&Rs out there have a provision saying you can't cause a nuisance. You can't interfere with the quiet enjoyment of somebody else's property. So it matters. So an enforcement action could be you're suing because somebody else is violating the governing documents. I'll give you another example, and then I'm going to ask Sam to give me some because he sees this stuff every day. He consults with the potential clients all the time, as do the other associates, or the senior associates. So another example would be, let's say your CC&Rs give you a specific view shed protection. Let's say there's a view of the ocean or of a beautiful valley, okay? And your CC&Rs specifically have language that protect everybody's view sheds. And somebody erects a shed that would otherwise be in compliance with the architectural guidelines and all that. So there's nothing wrong with the shed itself, other than its placement. Because it blocks your view shed of whatever it is that's being protected in your governing documents. And so you have to sue either the member or the HOA for not making them remove it, or both, for blocking your view shed. You're suing to enforce governing documents. Right. Sam, give me some more. We see a million cases. Give me some more fact patterns that would be enforcement. Because, am I wrong? Is this not a very broadly defined topic?
It is a broadly defined topic. Yeah, I mean, there are countless examples of this. One of them would be the way the board spends funds for the association. I mean, this could be in connection with maintenance of common area or failure to do so, right?
Okay.
So a homeowner can basically keep an eye on it, hold them to account, and when there's any type of wrongful conduct or red flags, at least, they can basically sue them for enforcement.
Right. So, as we've discussed in other podcasts, that one of the we talk about this all the time, fundamental duties of an HOA, in addition to enforcing governing documents, is to repair, maintain, replace common area. Here, it looks like they're violating both.
Exactly.
They're violating two.
And that's a very common one. Comes up routinely.
And it's an enforcement action.
Yeah, and it's a perfectly legitimate thing for homeowners to be concerned about.
What about, tell me this, do you ever get ones where the board is engaging in selective enforcement? Would that be an enforcement action?
Absolutely. I mean, selective enforcement, if they're being desperate in terms of the treatment and application of the governing documents to various homeowners, that's, reeks afoul of a potential selective enforcement.
If I want to build... If the governing documents technically allow me, either because they don't prohibit it, so I'm allowed to build a widget, okay, because it doesn't prohibit widgets.
Yeah.
And this board says, no, you can't have a widget, okay? It's violating my rights because it's not letting me build something that the rules don't say I can't build.
Correct.
But it's also an enforcement action because if they've allowed other neighbors to build the widget and not me, then they are, by law, not allowing me to do it under the governing documents and me suing to make them, that's an enforcement action.
Prima facie on its face, selective enforcement.
Yeah.
Right.
Which has the word in it.
Yeah.
Enforcement.
Yeah, exactly.
Okay.
Yeah.
So I think the point we're making here is that enforcement action is a very broad term, and it's broadly defined by the courts and the statute on purpose. Okay? So now let's get to something else that very few people think about as a separate issue, but they ask about it all the time.
Okay.
There are requirements, and I guess we can talk to me about the requirements in the Davis-Sterling Act.
Okay.
That in certain circumstances require a party to engage in basically mediation, alternative dispute resolution, ADR, but in the context of an HOA, we're really talking about mediation. Okay, which is just a fancy word for glorified settlement talks before a neutral. So the Davis-Sterling Act says in some certain kinds of cases, you cannot file a lawsuit until you first tried to engage in ADR. Tell me what the statute says in very simple terms, and then we'll take to the next step.
Sure. We're basically talking about Civil Code Section 5930 and other related sections within that statute. And what it says basically, Mike, is if you have an action for enforcement of the governing documents and it requires injunctive relief, or it's a claim for injunctive or declaratory relief, or a writ, then ADR, pre-litigation ADR mediation is mandatory.
So if you're suing for just one or a combination of those,
correct,
and only that's you have to do ADR.
And there's another scenario, too.
Well, tell me the other scenario.
And the other one is if you have one or a combination of those, right, injunctive, declaratory, or writ, coupled with a monetary claim that is below the small claims jurisdictional amount of $12,500.
Okay.
Then it's mandatory as well.
Okay. So if I'm suing for, just an example, I'm suing for declaratory relief, which is just a cause of action where you're asking the court to declare something. We won't get into it. But let's say that was the only cause of action. Because it's just for one of the three that he gave, declaratory, injunctive, or writ relief, we would have to engage in ADR prior to filing a lawsuit. Or let's say we were suing for dec relief and breach of something, and our money damages were more than or were less than $12,500.
Correct.
In that case, we would have to also
engage in ADR mediation.
But let's say we were suing for dec relief and our damages were $50,000.
It's not mandatory.
Not mandatory. Okay. So that's important for a multitude of reasons. Number one, even though a smaller percentage than you might think of the cases out there actually trigger the mandatory ADR clause, we, as a matter of course, and this is through, in the last my 30 years of experience in this, I figured this out many, many years ago when I was developing this niche area of the law on the homeowner side. And I'm one of the original pioneers that did that that focused as a not a specialty, I don't want to use that word, but focused as a focus, as a law practice on representing homeowners in disputes. We don't represent HOAs. And then figuring out systems and practices that made that representation as smooth as possible and as easy as possible for our clients and raised the success rates. Came up with a bunch of systems and policies that several of the law firms in this state use because they've been formed by people who used to work for me. Now, one of the things that I realized is that I could accomplish things at mediation for my clients that I could never get as a matter of law if we went to a lawsuit and won. In other words, there's relief that I can usually negotiate or often have negotiated in the context of a mediation that is not available to us as a remedy in a lawsuit. I'll give you one example. There have been times, we have lots of clients who come in and say one of their objectives or goals is to force somebody to resign from the board and not run again. Yet they can't serve, we can't have them there. They're bad people, they're destructive, they're horrible, whatever. Well, we just did an episode recently on HOA elections, and in that episode, and I don't know if that's aired yet, but we've already recorded it. In that episode, we talked about the specific legal conditions that would prevent somebody from sitting on the board or running for the board, and they're very few. And so if you were to sue, you can't make that one of your claims and get the court to give you the relief to forcibly remove somebody unless either they're legally not allowed to sit on the board. For example, they're not a member, they're just a renter, can't be on the board, okay? Or if they have been convicted of a crime that prevents the HOA from being able to secure their fidelity bond, which is required by law, then they can't serve. But there are very few other requirements, and the court will not interfere with the democratic process. But I can't tell you how many times I've negotiated as part of a settlement in ADR the resignation, either permanent or for a period of time, a year, 2 years, whatever, of a problematic board member. And that's a great example. So we steer a good deal of our clients through the ADR process, even though they often come to us saying, after they find out they're not technically required, they come to us saying, I want to skip it and just go right to a lawsuit. And we try to, if we believe it will bear fruit, or there's a reasonable chance of bearing fruit, 20% chance is good enough, because it is so, by orders of magnitude, less expensive to go through the entire ADR process than it is to even initiate the lawsuit, never mind prosecute one.
And it's faster,
And it's faster. So, unless it falls into one of the few categories for us, and we tell our clients what those are, we urge people to allow the ADR process to proceed, even if it's not mandatory under the legal provisions that Sam just talked about. So, why is that important? Well, Sam, why is it important? What have courts done? And then, let me ask you that. That's not a fair question. Sam, do you happen to remember off the top of your head, and I'm putting you on the spot, so if you don't remember, that's totally okay. Do you remember the holding in the Rancho Mirage case?
Yeah, Mike. One of the holdings was that basically on the issue relating to the enforcement, where pre-litigation ADR was mandatory for the enforcement, the court held that the prevailing party was entitled to all of their attorney's fees in litigation, but also relating back to the ADR process, litigation.
Okay, so if I'm understanding, that's exactly right. You nailed it.
Okay, good.
So basically, just to break it down for everybody in real simple terms, this was an enforcement action. There was a prevailing party. They're entitled to their attorney's fees. The question that the court addressed, because this was what was before the court at the time, the question they addressed was, are we just to award this prevailing party with all of their fees and costs incurred in bringing the lawsuit, prosecuting it all the way through trial, or do we also get to include all the money they spent in making the ADR demand and going through that ADR process? Because under 5930, under the conditions you described,
Correct.
In that particular case, ADR was required.
Exactly.
And that's the holding of the case, because that was the fact pattern before the court. That leads to another question, though. And I have not found, I could be wrong, but I have not found a case that addresses this issue, because maybe this has never come before the court, or if it has, they haven't opted to make it a published opinion, or they haven't accepted a case to rule on. But here's the issue. Oh, before we talk about that, I want to say one other thing. In Rancho Mirage, one of the issues that the court discussed during its holding, okay, was the public policy purpose behind the right to your pre-litigation ADR attorney's fees. Because the whole ADR process, the point of that is to avoid gamesmanship and to foster the potential settlement as a means of avoiding lawsuit, of avoiding litigation.
A good faith resolution.
Exactly.
Yeah.
That's what the court talked about, that public policy being behind this ruling or in support of the ruling. Which goes to my question now is, okay, what about in the cases we were just talking about where we have a client in the HOA engage in ADR pre-litigation, but it technically isn't required under the Davis-Sterling Act. It isn't. Let's say it's a claim for injunctive relief and money damages in excess of the small claims limitation, therefore doesn't fit into that requirement. Should they get their attorney's fees? Well, Rancho Mirage isn't directly on point because it only addressed the question of if it was required in that case. But no court, according to my, I haven't seen an example of a court ruling on whether or not that policy extends to any pre-litigation ADR, regardless of what was required. And so we don't know what a court would decide. And we tell this to our clients. We tell them it's unsettled. However, between you and me, and I think you agree with me, and if you don't, speak up. I believe very strongly that if that specific issue came before a court, we would end up with the same decision that we had in Rancho Mirage. Here's why. More so than in the Rancho Mirage case where ADR was required, that public policy is serviced. Here, you have two parties choosing to engage in ADR, not because the statute requires them to, but because they want to engage in good faith negotiations to avoid litigation. That services that public policy even more.
Absolutely agree. And the inherent public policy still remains. And the other component that speaks to that is also courts don't want to be inundated with avoidable lawsuits. They have busy dockets, busy, caseloads, these judges. And so they typically frown on parties that do not engage in good faith pre-litigation ADR.
Exactly.
Yeah.
So I think, although it's not settled, I can't put a name to a case and say this case holds this. I think that the ruling would be the same. And we tell that to our clients as well. Hopefully this will get addressed at some point in the future because I don't like non-bright lines. They bother me. But I think we've covered pretty much the attorney's fees issue.
I think we did.
I can say with a good degree of experience and certainty, and Sam agrees, I think, that in most cases, if it's an HOA dispute, you against a neighbor, you against the HOA and a neighbor, you against just the HOA, or vice versa, that the prevailing party is going to get their attorney's fees.
Agreed. Yeah.
Because we can always frame issues in terms of enforcement. And if we can't, we're creative about it. And if we can't do that, we find a statute. And in those few situations where we can't, we tell the client there's no attorney's fees here. And that goes into the decision as to whether to litigate at all.
Right.
Okay? Depends what your damages are. If your damages are $8 million, then a couple $100,000 or something for attorney's fees might not be a big deal and you want to sue for that. But if your damages are $30,000 and you're going to spend more than that on attorney's fees, it doesn't make sense. Okay? Unless you're going to get them back. So I think the takeaway from this episode is, in most situations in California, you as a homeowner, if you have to bring a lawsuit to enforce, or you've got to defend a lawsuit to enforce, or if you've got an HOA dispute, we can always frame it in terms of enforcement. You're going to get your attorney's fees if you win. And that really does provide a big sigh of relief to homeowners because they are at a distinct disadvantage. If the statute didn't have that, if there was no attorney's fees provision in the Davis-Sterling Act, we would have a very unfair law, and HOAs would have so much more power and be disincentivized not to violate the law.
It'd be untenable, yeah.
It would be terrible. It would be so unjust as to be, in my opinion, unconscionable. If you like this episode, please hit the like button and be sure to subscribe if you haven't done so to our podcast channel, HOA Hell. If you want to leave a comment or ask a question, we love to read those and we love to answer them. Until next time, everybody have a wonderful day.